on Bill number 162-33, which basically is an act to reform Article 3 of the Procurement Act, Articles 3, 9, and 12, but we're just focusing on Article 3 right now, which has to do with source selection. At the last meeting that we, roundtable discussion that we had, which we had on January 6, 2016, we actually started we ended on Section 22, Section 5249. But before we begin, I want to go ahead and state for the record who is here with us today. So we have Senator Frank Uggan, who's a member of the committee. We have Sandy Miller from the governor's office. We have Attorney John Brown, representing himself. We have Doris Flores Books, Office of Public Accountability. We have Mr. Siegfried Langsanen, basically from an interested party from the community. We have Jessica Toth from the Attorney General's office, and Attorney Robert Kono from the from the GSA, and myself, Tom Etta, committee chair. So we'll go ahead and we'll start on page 32, section 22, which is that particular section deals with the amendment of section 5249 of Article 3. We ended up actually it seemed like we were able to go through that through subparagraphs A, B, C, D up to G, and there were no questions except for the OPA had suggested adding a subparagraph G or H, basically that we should insert the language to the effect that a summary of the basis of selection. Okay. Please. Go ahead.
It's just really redundant, kind of, except it's also a little bit confusing. So bids are required to be public already by statute. And then proposals are required to be confidential by statute. So this seems to make it seem like, oh, well, now they're suddenly part of the public record that's required to be kept under 5249. And that's not really the purpose of the record under 5249. So we already have statutes that cover how bids and proposals should be treated. And so this just kind of muddies the waters.
Comments?
I just kind of a follow-up on that. There are other. I agree that other areas in the procurement law, it says that that only the winning offeror's proposal is public. Bids are open publicly, so no problem. But winning offeror's proposal is the only thing that ever is released And so this is kind of like contradicting other sections.
Yes.
And if the policy decision is to make all offers public, then we would need to also go back in and change those other sections. The other thing is that it kind of, I think there's a typo on line 14. It says, provided only that no trade secret, and then if you continue on, shall be redacted. I think rather than the word no on line 14, perhaps that should be provided only that any trade secret, proprietary information, etc., required to be held confidential shall be redacted. Because here, the way it's read, that no trade secret shall be redacted. And I think that that's, might be a typo.
Okay, anybody else?
Well, I have a question on 5249, first section, 2223. It says, all records shall be made and kept in readable form capable of duplication.
Okay, what page are you on, Robert?
32.
32. Okay, lines 23 and
2223.
okay.
All records shall be made and kept in readable form capable of duplication by the public. Is that by our determination what is a readable form? If someone comes in with a certain format, we don't provide that format, are we in violation?
Okay, what's your suggestion?
Well, I'm just asking for clarification as to what kind of readable form. It can, if, as long as it's as used now, or because we may not have the newest updated versions available, or the agency may not have the newest available version, like Word 20 or whatever, and we're on Word 6, because we don't exactly update regularly.
Understand. Okay.
You might be able to, all records shall be capable of duplication by the public. And delete shall be made and kept in that shall be.
I mean, we can make copies, but capable duplication.
Capable of duplication.
Yeah, that's, I understand that, but are we putting it in such a manner that the government may be in violation if we don't have the newest version?
Well, that's why I said by deleting those. That.
Or is there another word that you can insert there instead of readable? That would be all-encompassing, because we understand the intent.
Mm-hmm.
Okay, anybody else?
How about taking out the word readable in the form capable of duplication?
Say it again?
If you just take out the word readable,
Anthony suggested legible.
No, but I think what he's saying is that if it's an electronic form, if it's a digital file, 10 years down the road, we may not be able to read that format. I mean, will we reach back that far?
That's what it says deleted. And just capable of duplication by the public.
Or you could say accessible form, if the intent is accessibility of information.
Legible, accessible.
well, I'm just saying if we took out readable, then it's a form capable, whatever the form comes out, and that, for us, the government, we don't have exactly all the newest versions, and I hate to be immediately in violation, or we have to go get new technology.
So you're suggesting deleting, Mr. Chairman, I guess,
Just-
readable, and insert the word, if it's even a word, a.
Well, I'm
Kept
thinking,
in a form capable of duplication by the public.
yeah, that way it's we can give it to you if we have to just print it all out.
Another option to avoid the problem of you've made the form, it's in your file, but you can't keep it current because you don't have the funds to bring in the new media to do that. So you can just take, all records shall be made in a readable form and capable of duplication, but they don't have to be kept in that form. So in the first instance, if it's made, you don't have to update it to the newest form of PDF or whatever the next form of word processing is. Because certainly you have the ability now to make a form, make a readable form.
Well,
And all I'm saying is that doesn't have to be kept current with the changes in the technology.
So then we would change that to read, all records shall be made in a readable form capable of duplication by the public. And the "and kept" then saves us from having to continually update technology so that a Word file today can be read 20 years down the road. I mean, whatever that might be. Any comments? Sigfrid, did you have? Can you speak into the mic?
My concern might not be too related, but it's relevant to subsection D. Since I'm been in business for 28 years dealing with government agency, my concern is the drops justification in imposing terms and condition in the solicitation. You know, we might have all these records of procurement action, but if the agency are not in compliance in drafting the terms condition in the solicitation to promote participation by in the solicitation by the local bidders and offerers, then these are all nonsense. What I mean is we have a problem that they are not complying with the law in administration of bids. Like for instance, in imposition of delivery, just like it's specified here, subsection D, it should be drafted by the draftsman. But normally they're just guessing for the delivery requirement. They cannot provide justification that they seek the local bidders or local operators' expertise on how they came up with the delivery. Because to come up with the right delivery, then you have to seek the, you have to communicate with the manufacturers or the wholesaler in the mainland. And they're imposing delivery requirement that's not realistic. In that, that's why there's very small quantity of bidders are participating, like 2 bidders only, because they cannot meet the delivery requirement. I believe the laws are good. It's just a matter of complying with the procurement law. And I have so many experiences that the agency, especially GSA and GPA, are not complying with the procurement law. You know, because as specified in subsection E of section 5008, the specification, terms, condition, and qualification for the solicitation shall be drafted to promote participation in the solicitation by the local bidders and offerers to the maximum extent practicable, consistent with the needs of Guam. If they don't follow those that subsection, then there will be less participation, and sometimes there's no show or no attendance in the bidding, and it will be affecting Guam's economy because you know, if there's no bidders, then the agency will order direct. in the mainland. It's quite related because subsection D refers to be drafted, drafts, and dated by the draftsman. But they need to comply. They cannot just guess for the imposing terms and conditions. That's why I came here, because I thought it's just a question and answer that I have to relay my concern. Because I spoke with BJ last week, and he told me to just come here and tell my concern to the legislature. And I think to remedy that, there should be the amendment, like the delivery should be provided or offered by the local bidders.
Okay. I'll tell you what, Mr. Lingzon, in the format of the roundtable discussion has been going section by section to take a look at how it's basically drafted and to see what further amendments we need to make. And it's not basically a general open Q&A. And I think we would do that probably at the next discussion, when after we've gone through and taken a look at all the provisions and then taken in all the suggested amendments, then we can go back and then open it up again. But for now we're kind of going on a structured discussion. You had something that you wanted to add?
I was just going to comment on his discussion. It pertains to a recent appeal decision that we issued. And what it pertained to was the issue of delivery date times, where GSA had said 30 days for what may appear to be an off-island item that may have to be ordered off-island. And 3 of the 4 bidders were disqualified or deemed non-responsive because they did not meet the 30-day time frame. And the winning bidder, which was the third highest, not the highest, the second highest, said as specified, whereas 3 of the bidders said, we 4 to 6 weeks, 50 days, each one of them had a longer time frame, and there was nothing in the procurement record to indicate how did GSA come up with 30 days. And so he appealed it, but there was nothing from the record to show that the one deemed responsive, even though not the lowest bidder, was not acting in good faith. And so we had instructed GSA that if this bidder does not meet the 30 days, he should be penalized, assessed liquidated damages for failure to meet the delivery date. So that was his concern. And that was in a recent opinion, an appeal that we just issued less than a few weeks ago.
I'd like to just clarify a small point. Number one, GSA does not determine the delivery dates in by itself. It's also on the basis of the agency's requested needs. 2, at the time of the bid submittal, at the time of all of the bidders had an opportunity to ask for a change in delivery date, and that did not occur.
I have to repeat that, Senator, because it's like the bleacher.
Okay, I don't think I want to repeat basically the appeal procedure, the appeal process that you guys have gone through. So we're going to be kind of straying away from really what was the objective of this round table today.
Okay.
Okay. Sorry, sir. I know that you just said, I apologize, but I just have to add this. What the public auditor said is true, but I want to say that we have a delivery time. If we get notification that it wasn't delivered by submission of something from the agency showing that it was submitted, we automatically in the system issue out liquidated a notice of possible default. They got 10 days to cure, and if they don't cure, we charge. That's automatic, and nothing's different for this person. They just wanted to point out that's a regular procedure.
Okay. All right. Okay. So we're gonna go ahead and proceed then with So going back to Attorney To's on item F, subparagraph F, line 13, suggesting that subparagraph F may be redundant and may cause more confusion because there are already, and I know that Ms. Miller, you did indicate, I know that there's a specific, was it in the law, was it in regulations that I saw that the agency is prohibited from opening for public inspection the proposal submitted by the companies that were not awarded. So the only one that's open for public inspection is the company that got awarded.
That's by statute.
Yeah, oh, okay.
Yeah, that's for the RFP procedure, so proposals. That doesn't apply to the IFB procedure because all the bids are open publicly and read publicly. But for a proposal and RFP, it is true that you never submit the proposal of the offerers who are not awarded
Correct.
the contract. So
Yeah, they're not open for public inspection.
ever. Yeah, that's correct. They're supposed to be
Correct.
returned.
Yeah. Okay. Any further comments on the suggestion to delete subparagraph F?
Yeah, I think that we're throwing some babies out with the bathwater if we just delete the paragraph, because what we're talking about here is maintaining a procurement record, and it requires that the contract officer or the procurement officer maintain this procurement record. So all the pieces are in one place. These things tend to get shifted around, and there is no repository, no particular repository for the whole record. And the agencies have to go scrambling around to get those when there's an appeal filed, and it's a lot of work for them. So I think that having a repository and having the requirement of the procurement officer, contract officer to make this record and keep the record in one place is a worthwhile endeavor. And granted, there are proposals, RFPs, that should not be, unless it's awarded, it's not disclosed. And so all bids are proposals, and it says unless withdrawn, and you can add after that something to the effect of, or which are not allowed to be disclosed by the law or regulations, and that covers that problem that we have of disclosing things that aren't meant to be disclosed.
So add the language on line 13 to read all bids and proposal, comma, unless withdrawn, comma, which are...
Or unless withdrawn or are not allowed to be disclosed by the law or regulations.
Well, you could say for F, all bids and proposals, comma, unless withdrawn or not disclosable pursuant to law or regulation.
That's fine too. Yeah. I said it to the effect of, because I knew there was a better way to
Period.
say it.
And then you wouldn't even have to include all that extra language, such as trade secrets, proprietary information, because that wouldn't be covered by that broad language about not disclosable pursuant to law or regulation. Those are other categories of non-disclosable information.
Yeah, the provided to no trade secrets, I agree, can come out, but I also, the language specifically talking about purchase orders and contracts too, I think should be kept in there. Because we're talking about bids, proposals, contracts, and purchase orders.
I tend to agree with John. This section here is trying to summarize everything. It's an area to summarize, and that's why I had my thing, and a summary of the basis of selection. So to ensure that it is all there.
Okay. Did you get that? Okay. All right.
And just following on that with the last comment about the summary, again, I pointed out last time that there's a good model for that in 2 GAR 3114M, which requires a memorandum of the evaluation and negotiation. This is specifically for RFPs, and it could be, but it's a good model the way it spells it out. You have to include the evaluation factors stated in the request and how they were applied to determine the winner, such as that. Very detailed, a very good model for that kind of requirement.
And we don't necessarily see that for the IFBs. It's just assume that the low bidder or the lowest responsive bidder won, but there is, very rarely have I seen a summary
Yes.
as to the rationale. And I mean, you may not need it for smaller items, but for larger items, it would sure be helpful to know why they selected whoever.
Yeah, it's particularly important when they dismiss a bid because it's deemed to be non-responsive.
Non-responsive,
So
yeah.
the evaluation process in 3109 in 2 or in 3 is really important too.
Yeah. You know, to say, you know, there were 4 bidders, 3 were deemed non-responsive, hence bidder number 4 got the bid. And the other were deemed not because of A, B, and C, rather than looking all the papers, and I think that was why.
Okay. Yes, ma'am.
So I think the reason that a memorandum of decision is required for RFPs rather than IFBs is because for IFBs, the only consideration is supposed to be price. You don't need a decision, you don't need a summary of why an agency chose a bidder. If everyone else is disqualified, they go with the lowest price. That's the only factor that you're allowed to consider for IFBs.
But what about
is
the
lowest price.
What about
RFPs already have a summary of the decision in the memorandum of decision because the agency is required to, price is not the determining factor.
Right.
You have several factors and you have to weight them and you have to actually make a weighing decision as to the factors. But for IFBs, the only determining factor is price.
But
So
what
you
about
shouldn't
the-
need a summary of the decision because it's just price.
What about the IFB example that the OPA gave, where the
Well-
lowest bidder had the lowest bid, but probably needed an explanation of the being knocked out because it wasn't responsive.
Correct.
Well, those are
Yeah,
contained
and-
usually in the letters
Yeah.
to the rejected bidders.
Yeah, it's just a tick mark, non-responsive. Again, here, where I'm coming from, I think having a summary, even for an IFB, is a good practice. And why not engender good practices, rather than and have the agency summarize, okay, we know A, B, C. To me, I feel it's a good practice to have. And while you're correct, it is the lowest responsive bidder, it certainly would help when we have to look at it, why the second highest was selected, and the rationale, because they all did not meet the delivery date in this particular bid. We all had to glean it from reading all the different documents. We saw, for example, that the 3 bidders, 2 who were lower, did not win it. Again, a recap is certainly not extra effort on the part of the GSA as well, to let the agency know.
I have to disagree with you on that. I believe our bid status form that's attached, that we give to all the bidders, states exactly why a bidder is not accepted. It lays down why we consider them non-responsive, non-responsible, and we are not picking them. And we do identify who the lowest responsible bidder in our determination is. We give that to, we send that out to everybody who submitted on the bid. So they know right up front what our determination is. That's already included, I think, at least listening to everybody's conversation, in the bid status that we give to all the bidders that do not win. We give a notice of intent to award to the person we believe is the lowest, and we say, in 14 days we'll award if there's no protest. But we do tell people why we believe they don't get it.
Can I respond to that?
Yes.
If they're doing it already, then it's no imposition on them to provide it, if they've got that information. But the rejections that I've seen from the notice of attempt to award is that you were high bidder, period, nothing else. And it doesn't say anything about it. So even in a case where you have a low bidder chosen, and there's a question in the other bidders as to whether they were responsive, you found them to be responsive, and perhaps you shouldn't have. it's the same thing as finding them non-responsive, and perhaps you shouldn't have. So I think having an analysis, an articulation of the evaluation process that's required in the GAR is not a bad thing. If they're saying it and they provide all that information, it's certainly not going to be any more burdensome. And if they don't do it, then it certainly should be in the record so that on a review, there's something for a reviewing body to understand how the decision was made. It's very important. All reviews require a proper record. And if they can't make a proper record, if they don't have a proper record, they can't properly review it. And the decision typically is, we have nothing to review here, so we have to assume that the decision was arbitrary. So by making this evaluation articulated, you're doing a service for the whole review process.
As well as a recap of your own review that you had to done. Again, this I would view as the best practice, and why not engender best practices?
And it seems, at least from my layman's understanding of what all is being said, is that this is probably most valuable when the let's say the second lowest bidder is selected. And so,
Correct.
So certainly this documentation will be most valuable then.
Well, there would already be documentation saying the lowest bidder was disqualified for whatever reason. A letter saying you're non-responsive. So the lowest. So you would have a letter. You're always required by the statutes to issue a letter telling the lowest bidder you are non-responsive.
Okay, but
So
the
then
bottom
you have
line.
a record that they're non-responsive.
But the bottom line that we're trying to add here in the new subparagraph H is to have a summary of the basis for selection, regardless of the solicitation method. And if it's already being done, then as...
I think there's a difference here in what's being sought, because you have two issues. You have bases for rejection of bidders and bases for selection of bidders, right? The only basis for selection is lowest price, lowest responsive price. That's it. That's the only selection criteria. So what I think the OPA is asking for is one document that combines all of the rejections with the selection. But those are already covered in separate documents. And the issue is the practicality of requiring this extra summary, which is prepared by agency staff. It's not by lawyers. And they're going to mix them up, and they're going to put them all in one document, and then they're going to probably mess them up. And it's going to be another document. So when you have your agency staff putting all the rejection criteria in the document with the selection criteria, they're going to mess it up, and it's going to form the basis of more protests, because they're not lawyers.
Okay. All right.
Well, GSA's notices that they're describing the bid status, they are good for putting the bidders on notice what happened to their bid or who's getting the thing awarded. Where they are a bit lacking or could be better is in the context of appeal. Now, fortunately, only a small number of solicitations do get appealed, generally speaking. Unfortunately, they tend to be for some of the more important and needed services, more expensive services. The agencies that actually do best on appeal, quite frankly, are the ones that actually do include some kind of summation, even for IFBs. It's not a uniform practice as previously discussed, but it usually takes the form of a memorandum where the committee says, we select, even if it is based on price, bidder X because they had the lowest bid, and they summarize kind of the prices of the other bids, or bidder X was the only one that sent in a conforming bid, albeit not with the lowest price. The others were knocked out this reason. And then usually the formats of these memorandums are the committee just says, usually just 2 pages, so it's not a huge document with any exhibits, but committee says it's our recommendation that bidder X or whoever gets the bid or gets awarded the contract, and then it's submitted to the agency head. This is also very important. The agency head actually, in that document, says approve. And so you actually have three things going on. So you have, from the agency perspective, a very clear explanation of why they did that. And that actually enhances transparency and accountability, because somebody there usually approves, at the agency level, that transaction. And then finally, in terms of an appeal, you have a good record for the agency to fall back upon, because it is true that we've had several cases where, yes, on the form it says that the bidder's bid was high price, but then the basis of the appeal is, no, we were actually the lowest price bidder. And but all we have is that one form with the checkbox, and the bidder says this, and we have to really look to the record and other facts, whether or not that's substantiated. And there and again, the agencies, there are just a few of them, but they're out there, that do fare best on appeal are the ones that actually have this document.
Okay.
And like I said, publicly, it's transparency and accountability are the two things it really promotes for both RFPs and IFPs.
Okay. Chief Bora.
Yeah, my name is Ben Bora. I'm the Supply Management Administrator at ULG. At ULG, we practice what she's saying for both RFP and IFP. And on the memo that we have the President signs off to approve, we do spell out exactly why they're rejected, either the lowest price or not. And the evaluation committee would send us a memo saying why they're recommending, who they're recommending, and list out all the reason why they're rejecting the others. And that memo is part of the procurement law, package. And as they're saying, it will make their appeal process a lot easier if they just have something like that sign off, rather than going through. And I know what they're talking about when they have to go through all the procurement record. It's cumbersome and it's really hard. But when you have everything documented properly, it's easy for everybody to review and everything's there. And it, as he said, the form that they're talking about is really not explaining everything why you got rejected. Okay? But having that memo, and that memo really is just, I guess if they request for FOIA information, then they'll get that information. But during the bid opening, we have a bid abstract that we use, and that's where all the bids open at that time, and all the bidders understand who is the bidder, lowest bidder, and who could be awarded. But we also mentioned that we will evaluate all the package to make sure that they're in compliance with the specification and what the needs are. And by having that memo from the President sign, approve of the recommendation, that completes the package. And I'm not sure, but we haven't had an appeal in 5 years, something like that.
You haven't been with us lately.
Yeah. So I agree with the summary, because it will help the process move forward.
Okay, we'll go ahead and we'll move on. Okay. All right, we'll go to section 23, and thank you for the inputs on F and H. G, please. Okay. Yes.
So G is postal, either postal records of contract administration and contract disputes. Those are all postal records. And if there's a contract dispute, that's handled under the government claims act. rules that apply to that.
Okay.
So I don't think they should be kept in the same record. The record under 5249 serves the purpose of keeping everything prior to award and award in one place.
Okay, comments?
Yes. This is meant to be a procurement record. Procurement is defined in section 5030 O to mean buying, selling, purchasing, leasing, blah, 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 and all phases of contract administration. Contract administration is part of procurement. So all the matters dealing with contract administration and dispute resolution of contract dispute is part of contract administration, is part of the procurement process. And the Claims Act only applies to a very, very small portion of contract disputes, only to the money damages. There's plenty of other reasons to dispute a contract, and in fact, even if it's a money damage award, the dispute first has to be raised under 5426 at the OPA level. So, 5427.
No. Money
Yeah, right. It has to be raised through the procurement record. That's the Pacific Rock case. So it's got to go through that anyway. So you have to have this procurement record. It's got to include the contract administration. It's got to be in one place. One of the problems that we have with procurement is in the handing off from the solicitation team to the contract receiving team. Because those people don't know what was solicited, and the people who solicited don't know what was received. And so if you don't have that communication, that centralization of those records, there's a lot of room for miss.
I just wanted to state my cite to 5 GCA Chapter 12 does give, there is a procedure for contract disputes. This is a dispute between a contractor, this is post-award, basically the contractor would dispute an agency action or an agency interpretation of the contract, and basically can, once it gets the decision of the agency on that contract dispute, appeal that dispute to the OPA. So there is that procedure, and it goes all the way. GSA is correct, though, that for a dispute concerning monies owed, so if it's really a contract, or if it's a vendor, for example, and I think the legislature has heard quite a bit of this lately, if a vendor hasn't been paid by a governmental agency, then there is, and it's just the money owed. It's not, about the performance of the contract, whether or not they perform to specification or delivery time. Then essentially, what they can do is, if it's money, it's government claims. If it's contractual performance and some question about that, then it's a dispute process that's very similar to the procurement protest appeal process.
And we agree with everything. The AG's office, we're aware that the procurement also, in the definition of procurement, includes things that are after the award of the contract. What we're saying is that the purpose of this record under 5249 is to keep track of everything that's up to the award for protests. And there is a separate process. There are two separate post-award processes for contractors with disputes. There are money disputes, Government Claims Act, and then administrative disputes before the OPA. But those are, again, separate from the protest, bidding, and offer fights that you have. They're an entire, and they're kept separately. Currently, contract administration awards are kept separately. They're still public records, but they're not part of the record under 5249, because the purpose of the 5249 records is for protests, up to and including post-award protests, but the post-award protests are still based on things that happened prior to award. And so the contract administration disputes are separate processes, and so they shouldn't be lumped in with this record.
The law has always read in 5249, which is a requirement for a procurement record, says each procurement officer shall maintain a complete record of each procurement throughout the term of the contract. It doesn't distinguish between the solicitation period and the contract period. 5427 is for the authority to resolve contract disputes. That goes to OPA, in the same way a solicitation does. So to say that it was not the purpose of 5249 to include records having to do with contract administration is not the existing law, and it's not in the definition of what a procurement is. So I think that it's a nice concept to recognize that yes, there are two different things: the solicitation period and the contract period. But that does not detract from what the procurement record is meant to maintain.
And let me just add from classes on procurement, it is the entire process through contract procurement does not stop with the solicitation and selection. It goes all the way through, and that's how classes are taught. It's the complete cycle. So to take out one section, you're bifurcating the procurement.
Okay. All right. We're going to go ahead. We'll move on. Jessica, did you have anything else other than what you've brought up on G? I think there's been sufficient discussion on G. So
I think so. If you've read the ABA Model Procurement Code, which is what our current code is based on, G doesn't exist in our current code. It doesn't require the record under 5249 currently does not require administration records, and there's a reason for it, because those records are required to be kept under other statutes. This is we have to remember that currently this is not included in our current law.
Okay.
So when you say that the purpose of 5249 is to include these records, this is an amendment to add these records in here. They are not currently required in the
okay.
law.
All right. Any final comments on this?
Current law, whenever this 5249 was enacted, it was either in the 18th legislature or the 16th, says each procurement has to have a record throughout the term of the contract. So regardless of what the ABA model code says or didn't say, and I haven't checked on what the veracity of that is, then our law has always stated, from the time this idea that you have to keep a procurement record comes into being, has always stated that we're talking about the full term of the contract.
Okay. All right. I think we've had sufficient discussion on subparagraph G. We're going to go ahead and move on now to section 23. Section 1023 deals with section 5251 of Article 3 and is amended as shown, which adds, basically shows the deletion there, but then all records shall be presumed to be public, and the burden of establishing that a document or record is private shall be upon the agency or the person claiming that the document on record should not be disclosed or inspected. Any bidder or offerer or disinterested person may inspect and copy any portion of the record, except only those parts of the record which are protected as confidential or trade secret by law or regulation. This chapter does not allow limitations on access to public record based upon the purpose for which the record is being requested, if the record is otherwise subject to disclosure. Any comments?
Just one on page 34, line number 3. I think that we should eliminate the last part of the section, which, lines 2 and 3 rather, which says, which are protected as confidential or trade secret by law or regulation, and just shorten that to say, except those parts of the record that are non-disclosable pursuant to law or regulation. And that would also incorporate confidential and trade secrets, but those are not the only two categories creating non-disclosable portions of the record. We discussed one earlier, hence the proposals of the offerers who are not awarded the contract. That's just but one other category of non-disclosable procurement record.
Jessica?
So, we disagree with the presumption that the records are going to be public. This places the burden on the government to prove that the records are not public all the time, which there are very clear laws on what is disclosable and what's not disclosable. And this tilts the burden onto the government for every request. So we disagree with that burden shift. I'm not sure what to make of the language on page 34, line 1. It says, any bidder, offerer, or disinterested person. Is that supposed to be interested person? Or you could take out bidder or offerer, then you could just say any, if it's meant to be any disinterested person, just any disinterested person.
I think it's meant to be as broad as possible, so you are right. I'd agree with you there if we just said any person or
Yeah, any person.
may inspect, and that would include any bidders or offerers or any.
That would be any person, just any person. And then line 2, it says it starts may inspect and copy any portion of the record except only those parts of the record. It just, to take out the only.
No, I was saying
It's just the grammar. Except only. Just maybe take out the only. Except those parts of the record.
That whole section was to be rewrote, right?
yeah, that's what
Yeah.
that's what I recommended, just to say except.
And we
Except
agree.
those parts of the record, except those parts that are,
Non-disclosable pursuant by law or regulation.
right, yeah.
Only is,
Except those.
except those, right, take out only.
Yeah.
We also, it's really, the lines 4 through 6 are really unnecessary because we don't have any provisions or any sort of policies that state that the purpose for which the record is being requested is grounds to deny access. If it's public, it's public.
I believe the language that was objected to at the beginning about the presumption of a public record and that language at the end about not allow for limitations based upon the purpose are taken from the FOIA.
Correct, and we don't need to mix FOIA language into
Well,
these
they have the same
provisions.
purpose, which is to insist on disclosure. And you've said there's no policy in the law. Well, there is a policy that's represented in the FOIA, and it's the same language. So I don't think that we're forging any new ground here. We're plowing the same old field with the same purpose.
I think the statutes are already clear on what has to be made public and what does not have to be made public. And we're just adding new elements in for government burden and presumption.
Yes.
I think I'm going to have to differ philosophically. I think, in this age today with all the public records, everything now is disclosable and is for public record. And these might have been old, some time ago. So it is the duty of government to be more transparent and open. And so once, unless it is confidential, these should be available to the public anytime the public wants to see them. Yeah. So that's kind of like my philosophy on the public record. The citizens of Guam, the taxpayers of Guam have every right to come in and demand, ask to see anything should they so desire. And many states now are being graded on their transparency and access to records. And the more that we can make it available and public and while it may appear to be a burden, that's the way we're moving. That things need to be open unless it is truly a confidential area. So we need to step up to the plate to show that we're open and transparent.
Okay.
And we agree, and we just think the statutes are already very clear on what's public and what's not. And so adding these provisions stating things that are already stated in other provisions is just kind of redundant and rather unnecessary. The rest of this is very clear on what's public and what's not public. And this makes it seem like so when you say this chapter does not allow limitations on access to public record based upon the purpose, that makes it seem like the government has in the past been denying public records requests based on the purpose. Unless
The government has in the past been doing that, and that's why that language is in the FOIA. And the FOIA is a separate disclosure act from this. And if it exists in the FOIA but not in here, there's going to be some guys going to step up to the plate and say, well, it doesn't, the purpose is limitation is only in the FOIA. It doesn't apply to the procurement law. So it's important to make sure that we track the requirements for disclosure. There's no harm in doing this. It adds no burden to the government that isn't already in place because of the FOIA. And it does prevent an argument that's been strongly made and was adopted by a lot of courts, that the purpose of the person seeking this information was pertinent to the question of whether disclosure should be made. I don't think it is pertinent. It's not public information that purpose is pertinent. But I make it clear.
Yeah, I have to agree with Mr. Brown. Historically, in the many appeals that I've at least looked at, looking at the record, the complete record, I get to see things like just people or other entities saying, writing a letter, I'd like to see this procurement record, and it never goes, or in 99% of those cases, those requests, just can I see the procurement record, they're not responded to. It really does take, in my opinion, a FOIA request to get an agency simply to disclose a procurement record. I believe that the procurement law, the real intent of stating that it's a public record is so that you don't have to file a FOIA request. In fact, law procurement law has a separate cause of action as it's originally written if you request for that information and the agency doesn't provide it for you. You don't have to file a FOIA before going to court. You can file a court action based on that alone. So, and the intent is that you shouldn't have to do these things. You should, because they are public. You should be able to access how your government is treating bidders and solicitors and using the money that's been budgeted for contracts. So that's quite important. And there's a reason Mr. Brown is very passionate about this subject, and it's well-founded.
Okay. All right.
I just have one more comment.
Yes.
I'm sorry. So I think the reason that I think these provisions are a little bit unnecessary is because they also kind of cloud the waters. If you're going to make a public records request, you do make it under FOIA. And then FOIA governs how you access the records. This kind of muddies it and says, well, basically, you don't have any limitations on access. But what does access mean under this? This is not, if you're going to make a separate access to these records, then you need to be more specific. Then we have to have extra provisions to talk about how you can access it, when you can access it. Can you make your request during the working hours? Can you come in after hours? Can you make it in writing? Can you just write to an agency? FOIA, if you're making a FOIA request, there are all sorts of rules about how you make your request for access. You can come in, and they're very specific. You can come in and you can request to inspect the public records. And then you can ask for copies upon payment of those copies. This makes it seem like, Because access is so, you're mixing the FOIA language in here, but not including enough specific language about the access, that I would just keep it out and keep it separate as FOIA. Because this basically says to me, okay, the public can come in and access it, but what does access mean? Can they just write to an agency and say, send me all your records? You know, is that allowed?
I'm going to give my layman's perspective on.
She has a good point. She does make a good point, because we as the government agency also have to make what is reasonable access. So from that perspective, I do agree with her, because of an agency. I'll give you an example. Every now and then I get requests from the media. It's been a long time so. I don't remember if it was a FOIA request, but they did ask, and because it was the media, so we had to gather everything up, and put it all in a box, and then I had to have one of my employees be there to just watch what they were doing, just to make sure that they didn't take records, or if they wanted to copy records. So I do agree with you from that aspect, that there needs to be some reasonable accommodation to the public as well as to the agency to be able to make these records public. But the end of the day is it should be public. How it's made accessible to the public is another area that has to be maybe redefined through regulation or somehow. But I do agree with her from that point, being the entity who is charged to, say, make my procurement record accessible. So yes, so I'm coming back now to her side of the equation.
That's why we don't like the mixing of the FOIA language in here, because it's not enough. And so if you already do have access to these records under FOIA. You come into the agency during certain business hours and you request to see the record. And if it's public, it's public. And FOIA tells you how you can make your request. When you put it under here without, it makes it seem like you can just kind of however you want.
But if I could say, I do sometimes resent FOIA. I said, well, why couldn't you just come in to ask me? No. And that's where I'm coming from, because I've had agencies. I've been FOIA'd by GSA. I said, why did you FOIA me? You could have just come in and asked me.
Actually, I find FOIA as being somewhat adverse.
Yes, there is.
Adversarial,
FOIA
sort of.
It appears to be, whereas, if the agency would just say, come in, or, like students who are doing a project, they come in, and if the request appears to be reasonable that we can accommodate them, we try to, knowing that government record needs to be made public and open. That's really the underlying area.
I'd like to chime in on what was just said about reasonable access. I think reasonable is implied, but there's no harm in saying that the chapter does not allow limitations on reasonable access. And if it's appropriate, I'm not sure that it is, as some of the comments in FOIA is not the ideal procedure either. If it's appropriate, if our procedure is spelled out in FOIA, and I haven't looked at that in a while, then maybe the reference to that can be made. Access, how you access it is obvious, and it's well pointed out that is an issue. But I think that the reasonable standard, which the law applies over and over and over again, and discovers more about as cases are dealt with, just add in the word reasonable access in there, from what I've heard, is and what I believe is probably adequate enough. I just point out that Mr. Camacho mentioned before that the procurement law has always had an access provision. It's in 5485, not always, but for the last 20-something years, 1986. And it just says if a member of the public has had data withheld, improperly withheld, they can bring this action. So it didn't describe a procedure either, and the world hasn't fallen apart.
Can I make just one statement, just for clarification?
Sure.
FOIA is a provision that provides or requires the government to provide the access materials within a time frame.
Right.
That's the main purpose. But there's nothing there that prohibits a person from calling in and asking. And when you said GSA FOIA'd you, it was based upon, I just want you to know that it was based upon the recommendation of your office that we FOIA.
I don't recall that.
Yeah, well, that's what had happened, because you had inquired why we did that. But the purpose of, but using FOIA forces the agency to give it within a time frame.
Right.
Okay, either 4 to 10 day, additional 10 if there's a need for trying to gather all the information. But there's nothing that prohibits in the law now that says that you cannot just make the request. You may not get it right away, but FOIA doesn't. But there's no FOIA requirement that way. You know, FOIA just forces the government to drop everything and do, the agency drop everything and get it together.
Okay. Okay, I think we've had sufficient discussion on that section.
I just wanted to add, Senator, so also, just to warn you, is I usually the one person who actually goes through the entire record page by page. For the at least the record subject to OPA appeal, I would say well over 80% of these procurements have records in excess of 5,000 pages, and there are those that have probably in excess of 10,000 pages. So we're not talking about small records, especially in a construction project or a project that's been ongoing, like a highway project. It would literally take somebody, or on average, maybe 2 weeks to go through a record like that page by page. And that's just scanning it, you know, not even reading every line of every page. So there is some merit to the argument about reasonable access and how we get some of these monster records to the public. That's all.
Okay. All right. We'll move on to section 24, which amends section 5252 of Article 3, rules for procurement records. Okay. Any discussion? Shoot. Go for it.
So we have an issue, I guess, with the independent cost analysis prepared. Ethics in public contracting usually requires that to be kept confidential until after the award of the contract. So it's 5252A.
12 to 14.
13 and 14. So it's supposed to, the regulations that maybe shall protect the integrity of the independent cost analysis, but that's already kind of covered under ethics in public contracting. So we're not sure why we're going to have extra rules regarding that. It's again already covered.
Okay. Comments?
I think if we have rules, ethical, there's nothing in procurement ethics that I'm aware of that speaks to this. Maybe there is some ethical rule in the industry that prepares its cost analysis. But whatever, we're talking about protecting that ethical rule because that's part of the integrity of the system. If there's an ethical rule, it's implied to be part of the integrity of the system. Otherwise, it's not an ethics rule. And so, if it's important to protect the independent cost analysis with some kind of ethics to cover it by integrity, I don't see the harm in putting it in there. But I don't see any, because I don't understand what this provision is even getting at. It was obviously taken from another source. And take it out if you're not concerned about protecting the integrity of the independent cost analysis. If you are interested in protecting the integrity of the independent cost analysis, leave it in.
Okay. Further comments? Okay. Any further comments on subparagraphs B through G?
I guess G,
G?
We just have the same statement that, again, there's going to be regulations promulgated to clarify those records that are accessible. And we think the statutes already clarify that, what's public and what's not public and what's confidential. So,
Yes.
Actually, this particular area should be addressed by regulation. Here's why. So, normally in the Superior Court, there is a procedure to conduct discovery, to actually obtain records from the adversarial party. What some of the appellants are doing at the Superior Court level is using things like FOIA, using things like the procurement record to get the records not only in a shorter amount of time, but at least in the case of preparing a record. For example, if they were to draft or if they were to file a writ of judicial, or writ of review, for that procedure, it's the agency that has to not only cough up the transcript of the proceeding, but pay that cost.
Yes.
So these are subjects that kind of holes in our law where there's really no uniform application. So, that's why these G would be necessary, because this squarely puts it on the drafter of the regulation to at least address when and how records are supposed to be produced during the pendency of an appeal or judicial review. So you'd finally have a uniform procedure of disclosure for that.
But, question. Okay, thank you. But if it's already been filed, the appeal, that becomes automatically a public record. And what you're talking about, those records that are accessible during the pendency, that's the documents that are already filed by, for us, GSA or the government agency, that we are using. And other than those documents are confidential or trade secrets, they're all already submitted to, and even those we put under seal to your office.
Okay, I'm talking about basically the adversarial use of these provisions to basically, for a party in an appeal before the Superior Court, to use various provisions to its advantage. Basically, instead of waiting 30 days for a discovery request, we'll just FOIA and we'll get the documents in 2 weeks, or so on, or 10 days, or whatever it is. Likewise, depending on how they file. Once again, it's kind of a cost-shifting thing. It actually subsidizes their litigation to use certain causes of action to get these voluminous documents. And yeah, sure, at the end of the case, and that might be a year or two, in some cases, the agency can say, if it prevails, that the adversarial or the appellant should pay the costs, and then maybe the court will award that or not. But in the case of, for example, a transcript of an OPA appeal, you're talking about costs exceeding, a few $1,000s. But that's just the use of these various sharp tactics to shift time burdens and cost burdens on the government, literally. And that can be addressed through regulation, and that's why the issue is not that whether or not these documents should be public, and maybe when, but how are they to be disclosed during a judicial review, for example.
Well, excuse me, I'm confused on this. But when we file it, if GSA files an answer or the procurement record, you guys are mostly the OPAs, which should be publishing it on the website, but you don't. You say, please contact so and so if you want to get the procurement.
It's too big.
Because it's too thick.
It's
But
too
it's
thick,
but
yeah.
it's available.
Yes.
It's available. So there's that's where I'm having the confusion, because it's already there.
If I can speak, if it's already there, obviously it's disclosed, but this has to do during the pendency of a protest or administrative judicial appeal. Obviously, the regulations cannot write the rules of disclosure for judicial appeals, but everything is stayed during that process. So if it's stayed and you ask the OPA for some documents, well, the OPA is not supposed to act on that solicitation, and is disclosing documents acting on that solicitation. This is saying where it's necessary, these kinds of regulations of what do you do with the files during the stay period, while it's pending with a collateral action in the Superior Court or whatever, during that pendency. We're not talking about the rules for disclosures. They've already disclosed them as part of their process. You've given them the record, and that's on the website. That's not what we're talking about. We're talking about the pendency of this protest, the pendency of this judicial review when it's stayed.
I have a question. Does the term judicial review include the civil action as well? Or is it just writs of judicial review?
We're talking about the pendency when it's stayed. When the protest starts, there's a stay. That's when the pendency starts. And if that gets appealed to OPA, that gets appealed to the court, the stay still is in place. Who has custody of the records? OPA. Can OPA respond to requests for disclosure? That's doing something with solicitation.
So I'm just asking if it
Yeah,
includes the civil suit as well.
it would-
Because under the later provisions,
whatever the
a civil
judicial
suit is
review
also
is.
going to be allowed. So is judicial review intended to cover both of those types of Superior Court reviews?
Well, looking at the language, I would say that, yes, it's broad enough. It doesn't specify by writ or civil action, it just says judicial review.
Yeah, well, a civil suit is different than judicial review generally.
Yes, but the rules for OPA having to step aside during the court action don't apply to, it could apply to a writ
So
if it
maybe-
involves the same factual situation.
So
It could
maybe
involve a civil action.
the term Superior Court action or
No, because
Superior
action
Court-
is not a writ.
I know.
Judicial review, is that puzzling to you, what we're talking about here? Something that's being reviewed by the judiciary?
Yes, because there's later on there's two types of Superior Court processes that are going to be allowed: judicial review and civil suit. I'm just asking if maybe you should add civil suit in here, or maybe use a term that's doesn't just because judicial review is a specific thing. Judicial review is a writ of judicial review, and that's going to be allowed later. But a civil action is also going to be allowed. So I'm just wondering if we want to add in and civil action, so it's clear that it's for all of those. For judicial.
Well, you can make it, we're looking for a broader
Any-
term then. You could say, or appeal before the an administrative agency or the Superior Court of Guam.
Yeah, that's what
Or
I'm
you
asking
could
about.
be broader. You could say
Yeah.
the courts of Guam. and then
Yeah,
that
or
would-
any
That would be the federal,
or any-
Superior and Supreme Courts of Guam.
appeal to the Superior Court of Guam. That would cover both.
Actually, I would just say courts of Guam because Superior Court, some of these go all the way up to the Supreme Court.
Yeah, any appeals to the courts of Guam, I think would cover, because judicial review is a very specific term generally. Like it refers to judicial review.
So there'll be appeals or,
Just appeals to the courts of Guam, I think would probably cover everything.
okay.
Because otherwise, you would have people saying, well, you can't cover, you can't write rules and regs about what happens if they file a civil action.
Okay. All right. Okay. Anything further on section 24? If not, we'll move on to section 25. And 25 will actually be the last section that we will cover for today's roundtable. So section 25 deals with adding a new section 5254 pertaining entitled Special Provisions Applicable to Source Selection. So let me open this up to Mr. Brown for some comment, to open the comments on this one.
Background. This bill is attempting to adopt a new method of source selection, the RFCP, and it's intended to. It's also intending to mimic the provisions in the 2000 amendments to the ABA Model Code, bringing in public infrastructure project contracting. You'll see in the subsection B, for instance, discussion, the design, build, operate, maintain, design, build. These are methods that we can't do under our existing methods of procurement. This section is taken out of the suggested model code having to do with that new form of public infrastructure projecting sourcing. And that's all I can tell you about it. Some of this is just a little bit over my head, frankly, when it gets into making the distinctions between some of these methods. But this was written by people who do this all the time and have been doing it for a long time, and so I just that's our guide here.
What is RFCP? Should we define it?
It's previously, there are new provisions previously, yeah, 5212, 5214.
The new 5212.
What section was, I think it was,
I don't remember what section of the bill it was, but it, yeah, and early on.
Yes, that's 5212 begins on page 8.
Yeah, section 5.
Request for competitive proposals.
Yeah.
Page 10.
It starts at page 8.
yeah, section 5, competitive seal proposals. Okay. Any comments?
All you
In the model code, this would have appeared in Article 5, but since we're enacting the method of source selection already here in Article 3, without this, we would leave a big gap in the ability to do that properly with those big projects. So,
The AG's office previously commented on this section, and just it was just suggested that it might be a good idea to solicit comments from contractors who actually deal in this kind of work to see if they have any input.
Yeah, I guess my concern about this one is I don't know anything about competitive sealed proposals, and I think maybe just some information on when is this type of source selection a good idea, when is it desirable, why would we choose this over the others, just maybe some sort of an analysis. I don't know where we would get that.
we went through that when we discussed that Section 5 to begin with. the competitive sealed proposal was written in our law, in Public Law 16-124. There was a provision for competitive sealed proposal method of source selection. It is what is called, in the vernacular, best value. It's not the lowest price, but it's not a professional service, and goes through that kind of evaluation process. It allows a trade-off between price and perceived value, quality of the bid, of the offers. So the other people call it negotiated contracting method. But our law originally called it competitive sealed proposals. They obviously ran into problems with it because it is a little bit laden with moral hazard. I mean, the best value is a beauty contest. You know, it's in the eye of the beholder. So if we're going to use this, we have to use it judiciously and provide a lot of safeguards to try to protect the eye of the beholder. And those are spelled out in that new version 5212. It puts a lot of limitations on it.
If I could, though, I think Ms. Miller's comments are very appropriate, because I was very confused, because even after we went through that section now, and my memory is starting to come back, is that when is it appropriate to use it? And that I don't think was well defined. And, you know, because I kind of used the issue of could it be used for like buying cars, and you said no, but there wasn't, you know, because you could argue, well, I want this kind of a car because it's the best values. You know? So there were kind of areas, gray areas as to when is it appropriate, and is it meant only for construction? And maybe at least that would be the definition, is this is only for construction.
But
Yeah.
I thought Section 5, though, gave, in paragraph A of the new 5212, it talks about the conditions for use. And on page 9, it talks about the method shall not be used when, and it gives conditions that if they exist, it shall not be used.
I apologize if I don't remember everything that we did back before Thanksgiving. I am aware, though, of a protest that was filed very recently with DPW over the term best value. So when I hear best value and that it's a beauty contest, I mean, already that's a term that is being, tossed around in protest. In fact, we're waiting out the 14 days before someone goes to the OPA on what is best value. Hopefully that should run soon. It's just things like that, or if we can head this off, or at least clarify going forward in the future, maybe we can address it here at this level. But yeah, I agree. I think this is something that maybe we just need more input from the outsiders.
It would help to have input from the outsiders. And there's plenty of outsiders that have a lot of, this is their norm. Best value is the norm in federal procurement, and it has been for some time, this negotiated contract process. And they have a lot of FARs developed around it, and a lot of case law through the GAO decisions about what you can do. It's complicated. I'm not saying it's easy, but this is for complicated kinds of procurements. And it's not just construction. It can be for hiring highly skilled plant managers, sewer systems, other kinds of technology. So it's not just the things, it's the people can be used for this. In fact, the feds use it for just about anything. They use it for janitorial services if they're in a secure zone or something like that. There's a lot of uses for it beyond what we have here, because we're just starting on it. We don't know what the kinds of discussions that you can have. Man, there's pages and there's cases out the wazoo about just the discussions that you can have during this process. We have to go through a learning process. So I've tried to contemplate a number of limitations that we just can't use this willy-nilly. It will take a learning curve. But there is no place in Guam procurement law today for best value. We have low price, which is comparative sealed bidding, or fair and reasonable price after you selected the best qualified in an RFP. And those are the only two methods we have. So there's no way of getting into this trade-off. And the trade-off process, it is a beauty in the eye of the beholder concept, but when you look at the way the feds do it, they require a full matrix evaluation, this summary of how you got to where it's very detailed and filled out, so that it tries as much as possible to objectivize this beauty. And it's not ideal. But it's, unless we're going to go to the low price all the time, or pick someone we think is the best qualified, which is also a beauty contest, and then pay them whatever they're willing to take as fair and reasonable, we need something in the mid-ground. And this is the one that the rest of the country uses.
Okay. Yes, sir.
Well, my comment is for the design, build, operate, maintain, and design, build, finance, operate, maintain projects. That's page 35, line 16, subsection B of 5254 is proposed. Is in procurement, the procurement statute, essentially, for example, where it talks about the existing methods of construction, or the differing construction methodologies. Those are well defined, each and every one of them. Here, these are new, as Mr. Brown points out. We've done them though. For example, JFK is a design, build, finance, operate, maintain that was authorized by special legislation it's almost a decade now. But that's just an example of one of these types of projects. But we would need in the statute or regulation to define specifically these types of projects, just like we define the existing construction methodologies that we use.
You know, I do recall, in fact, I believe I had introduced a bill.
They're defined in there.
And I don't know if I don't think it was put in 5 GCA, allowing the use of the design, build, operate, design, build, finance, operate, maintain, and it had to do with the utilities. In fact, that was how GWA, many years ago, was able to get something like 15 water wells constructed. They bidded it out, and they had a company finance it, operate it, build it, and all that. So there's something, but I don't think it was put into the procurement law.
Yeah, when it's not put in the procurement law, and the JFK, I believe, law is like that, then it becomes, to cite it, it's just public law, blah, blah, blah.
Right.
And then it's very difficult to find. Not that it's not viable, but to find a public law, for example, it just doesn't immediately come up on the Guam compiler's website.
Right.
And unless it's codified. So, and I believe I think I do remember that law years and years ago with GWA water wells,
right,
to get us in compliance with the Clean Water Act. But even in those laws, for example, in the I believe the JFK, the law authorizing JFK, essentially they clearly spell out what a design, build, finance, operate, maintain project is with great specificity. So we just need to incorporate those types of definitions in this statute.
Those definitions do exist in the model code regulations, and in the comment to the original 6124 says that because this act intends that the policy office shall adopt implementing regulations, model regulations, ABAs, are also available and must be examined. So, and it mentions also the commentary, because there's a lot of commentary on this in the new model code regulations. And they're all of it's in Article 5, which we're going to get to. So to some extent, we're getting the cart a little bit before the horse, but we can refer to those. We have this authority here in the comment, says you can look to the model code for their regulations and comments. So I think that takes some of the guesswork out.
Okay.
You know, I too remember the GWA build, operate, transfer because that was early on when the agency first became autonomous.
And this was right after a major typhoon.
Yeah.
And we needed to get water wells up.
It might be, you know, and without looking at it for sure, but if you're looking for it, one place I would check would be the GWA regulations themselves. That there was something about them that they just kind of had that authority to just do it for themselves.
I know I can find it. I introduced the bill.
Excuse me.
Sir.
You're at the, well, I'd like to go back up to 2, line 12, same page. I just have a couple of questions. It says right here, the Department of Public Works shall appoint the most appropriate qualified engineer in the department to serve on evaluation and selection team. Two or three issues. Number one, other than DPW doing construction, they may have delegated out that request to an agency for a particular project or to do it. That particular agency may not have a qualified engineer in the department. And number two, when you're saying a qualified engineer, are we talking about someone licensed by the appeals board or someone that is holding a position within the department? And three, what happens if the agency hires a engineering consultant to develop that project? I'm just kind of a bit confused about those points.
I also have questions about that. Because I know some of the autonomous agencies like GPA and GWA have their own engineers. So is this forcing a DPW engineer onto them? Or are they not allowed to use their own engineers? Or?
Well, I think in the case of GPA and GWA, they do their own procurement, right?
Well, this says in any solicitation.
Huh?
This says in any solicitation for architectural engineering or land surveying services. So GWA and GPA do some engineering work. And so this says that the Director of Public Works shall appoint the most appropriately qualified engineer in the department to serve on the evaluation and selection team. So, one is that implies that there's going to be a team, and that GPA and GWA are going to have teams, or whoever is going to have a team, and then DPW gets to force an engineer on them.
Good question. And I know that to the question that Robert had about whether these qualified engineers in the department are licensed, I don't believe they have any PEs up at DPW there.
Yeah.
They're,
They do at GWA.
Oh, at GWA and
Yeah,
GPA,
yeah,
they
GPA.
do.
I think there's only one right now.
But at DPW, they,
That's your G, Sunny Bears.
well, yeah, but at DPW, I don't think they even have a chief engineer
No,
yet.
the DPW, the last person who held a PE was the chief engineer.
Right.
And he resigned like a
Right.
year and a half ago,
Yeah,
and they haven't been able to fill it.
right.
And they're using Parsons Transportation Group as their design,
Right. Yeah.
as their consultant for all the design.
Yeah.
Yeah, and may I also inquire, when you say qualified, not only if you say it's the department holding the title of engineer, but there are different kinds of engineers, mechanicals, structural, electrical. I mean, in that field, is that the intent?
That's why I suggested that they appoint the most appropriately qualified. I mean, you wouldn't want to appoint a a mechanical engineer if you got a earthworks problem.
Okay, but the engineer, it's in the department, and,
Well-
and you know some of them.
Yeah, I'm hearing that, yeah.
So there is a question as to
Yeah.
if they have to be appeals board licensed.
Well, it
And-
says qualified, it doesn't say appeals court, appeals license, because, for instance, if you contracted with someone to do this work, they may not be licensed here, but they may be licensed in every other jurisdiction, and that might be appropriate. I don't know whether that's going to pass muster with appeals court, with appeals or not, but
They would get
it
a
it didn't say,
temporary
it
license.
didn't say license, it just said qualified.
No.
Because you're not doing the work. You have to be licensed to do the work. Here you're just, this is just part of the evaluation and selection team. This is not to go out and build the stuff. We're talking about the evaluators. We're saying the evaluators need to know what it is that they're evaluating. So you want someone who's appropriately qualified to evaluate.
But that would be different than just an engineer, because an engineer would be able to design and supposedly design and be able to prepare the documents properly. A person who's holding a position, I don't want to disparage anyone at DPW, but if they're not licensed, they cannot practice outside the department, outside the government. They are just in the government. And if you're talking about qualified,
They're qualified to, they may be qualified to evaluate. They don't necessarily have to have a license. They may be retired. They let their license lapse. They may have 50 years of experience in doing this, quite qualified, but with no license.
well,
It's not a, the licensing is a restrictive kind of thing. Qualified is a very, very important thing.
then wouldn't it be better to take out the word engineer and just say the most qualified?
Yeah, that wouldn't hurt.
Shall appoint the most appropriately qualified what?
Professional.
No.
No, person?
Okay, you're trying to broaden it, so,
Except maybe person, but
Okay.
professional is kind of,
Well, it's not just any profession. Again, it's the adjective is appropriately. Appropriately qualified. But person is fine.
yeah, I've always thought a professional is somebody who's, somebody with a certificate or with a license.
Yes, that's
Yeah.
true. Yep. The person's fine.
and I'd add, just to cover the, I guess the issue brought up by GSA, in section 2, you could say, in any solicitation for architectural, engineering, land surveying service above 500,000, would it be appropriate to put the chief procurement officer, comma, director of public works, comma, or the head of a purchasing agency? That language.
Yes.
Just to cover, not every agency will have engineers, but for example, even DOE hires or requires engineering services from time to time. So
DOE hired an evaluation team.
I'm sorry.
I think we might be skipping the, so we kind of skipped straight to 2, but I think this problem in 2 stems from A1, and where it says the director of public works shall be responsible to conduct the procurement of such services. So this limits it to DPW, and I think if we add in the language, the director of whatever agency.
But the whole thing goes back to line 3 there. We're talking about requirements for professional services of architects, engineers, and land surveyors. So GSA would not get involved in that solicitation. I mean, I would think you would use those professionals for construction. And anything construction comes under DPW.
Well, not anything, right? Because this RFCP is supposed to be broad enough to cover things like design, build sewers, anything infrastructure, which would, or design, build structures. So GPA. So maybe we should include
Purchasing.
the heads of other purchasing agencies.
Right, yeah.
Yeah.
although I know GSA has some problems with.
I'm sorry, Mr. Camacho had raised a point earlier on number 1. Did you want to throw in the AG in there too? That's what I missed it.
Oh, no, I was talking about number 2. We were discussing 2, and then we started discussing number 1 again. Yeah, I guess it does raise a point. I believe under the Guam procurement law, yeah, professional services of architects, engineers, and land surveyors are generally procured by DPW.
The agency.
Pardon?
The agency, the law says they would hire, it would be under the responsibility of the agency procuring their service.
So then, the issue is whether, at least for me, if that's true, it's not limited to DPW. And the issue is, are we going to limit this to DPW here? If the answer is no, then you just delete number 1 and add the language, Chief Procurement Officer, Director of Public Works, or Head of a Purchasing Agency in the second paragraph.
I concur. That's kind of what I was intending to use. Maybe 1 is unnecessary, and then we add that the heads of other purchasing agencies are allowed to appoint their own engineers.
Okay. Any further discussions on that?
Well, it's been pointed out that the structure of the procurement law is that construction is within the purview of DPW. And I think that it's important that we, as we are learning how to get this new method off the ground, that we have some expertise develop in at least one place. And by putting this in the office of the DPW, in the hands of the director of DPW, we start that process. We create the seed for your sourdough for the next loaf of sourdough bread. It's appropriate for me that we keep the distinction with that this is a construction related thing. You don't pay these guys $500,000 for nothing. They're there to help the construction, a construction project. So it's services, yes, but it's related directly to a construction program. You're building something. That's why you have these people on board. So it is not inappropriate to have just the Director of Public Works to do that.
I think I would have some problems with that simply because, when it comes to the large ticket construction items for horizontal projects, roads and bridges, DPW, of course, would undertake that, but the other agencies that undertake large construction projects, there's GPA, and they've probably got a larger pool of, and they utilize a lot of consulting engineers also. So to then require GPA to go to DPW to build their power plants, I don't think is going to work.
Again, let's take a focus on what the object here is. The object is to make sure you have one qualified engineer sit on the evaluation team. These are not the people who oversee the whole construction project or anything like that. They're saying when we're doing these evaluations for these major projects, we want to have an appropriately qualified person sitting on the evaluation team. At least one. And then GSA wants to have one as well. If GWA wants to have one, GPA, whoever establishes the evaluation team can add as what they want. Other kinds of qualifying people. But at least if we have one person or one officer in charge of identifying one person, it gets used to how this process works.
Okay, we'll bookmark that.
Well, I just wanted to add, do you really need a qualified engineer to procure the services of a land surveyor, for example? Mr. Brown? That's one of the results that would occur if this law is passed as written.
Well,
I thought we changed the
we
word.
changed it into qualified person.
Okay. All right. Any further discussion on page 35, page 36. On that one, I think only on line 8, I think that should be subparagraph D. So you have subparagraph C, estimated budgets. Subparagraph D would be the design requirements may. And then on page 37, on line 21, does that require the word at the end, independent peer reviewer? So if the Director of Public Works determines that it is not in the best interest of the department to contract with an independent peer reviewer so designated, the director shall contract with another independent peer reviewer.
I have a question. Oops. Okay. On page 37, line 6, small 3, I. It says pay stipends to unsuccessful offerers, provided that the amount of such stipends and the terms under which stipends will be paid are stated in the what is the perception of the stipends?
I believe this pertains to if in preparing the solicitation it becomes a high-ticket item, then a company may not be willing to participate if they're going to have to, invest large sums of money to put the proposal together, and if they lose, that's a big loss to them. Whereas the stipend kind of mitigates that.
This is a very common practice. You see it in a lot of the federal contracts when you have big ticket items that are up for bid and you want competition. If you want competition, sometimes you have to pay for it. So you agree with, when you do your bid, we'll pay everybody, we'll underwrite the first 100,000, or the first 1 million, or in some cases it's millions of dollars that they're willing to pay to get the competition, because putting together a power plant on an island can be a very expensive process. You can spend a year with several engineers just coming up with a bid, because you got to cost it. And if you cost it, you got to design it. You have to have a model in mind. All of that can take an awful lot of time and money, and you're not going to get people to bid on it if they have to bear the full risk of the loss of that investment in bidding on the contract. So you don't have to have it. If you're going to give it, you put it in the IFB. That's all it's saying. If you're planning to pay a stipend, put it in the IFB. No stipends after the effect.
In the RFCP.
RFCP, yes.
The best, the immediate example that comes to my mind of that issue is when we had ERA funding, DPW put out a bid essentially for design, build, or for repairs to 40 schools and replace aircon systems. So a bidder would then have to go to all 40 schools, evaluate what had to be repaired in terms of roof cracks, bonding on the roof, and also to replace the aircon system, which is quite a bit of work. And I think there were only maybe a handful of bidders who even submitted bids. Yeah. So this actually, I think, with a stipend, might encourage bids. However, with current funding, I don't think the use of a stipend will be very often, unless we have something like ERA again.
Okay. All right.
Just one other observation on page 37, section E, where you say the Director of Public Works or the head of the purchasing, or whatever the term we're using now. The head of the purchasing agency.
Okay. All right. This takes us right up to, this completes then the proposed amendments to Article 3 of the procurement law. So starting in section 26 is actually Articles 9 and 12 which has been reviewed and gone over a number of times. We had two bills that were introduced, both of them vetoed. The first bill, when it was vetoed, took the governor's objections, incorporated it into the second bill that was introduced. The second bill got vetoed again. And so what we have now in this version incorporates the governor's objections that were stated in the second veto. So hopefully with those incorporations, we have then honed in on where that field goal is, and that there should be no more objections to Articles 9 and 12. And of course, Articles 9 and 12, we had several round tables on that also. But we're going to need to go then back to possibly one final round table wherein we go in and take a look at, okay, here were the concerns on Article 3 that we had discussed in the last 3 round table discussions, and here's what probably how we should move forward. Okay.
So will we be talking about Section 26 in the next?
Well, like I said, I don't know that we need to discuss it again. I mean, we've had.
From OPA's perspective, there is one section we object to, and that's number G, because we did address that through our own rules and regulations.
Number G.
On page 40. The
Well, we
disqualification.
could, but I would like that we finish first Article 3.
Oh, okay.
Okay.
Yeah, and these new sections are actually, there are differences from the previous bills introduced. So we have new comments based on the new revisions.
Fine. So why don't we finish Article 3? Let's get that wrapped up, and then we can go and look at 9.
Can I ask, since we've I don't know how many roundtables we've had on this now, we're going to go over it again, is that people put their objections in writing well before so that we can all understand them and go through them a little bit quicker?
Okay. All right.
That's if we get the revised bill with, because I think, correct me if I'm wrong, your concept is to essentially, with all the comments we made, whatever amendments, grammatical or otherwise, we'll put in, and then we'll review it again.
Yes.
And go through the suggested amendments we've already discussed and look at the final version.
Yes.
For Article 3. Okay.
Yes. Okay.
So,
All right.
so when your office is prepared to distribute that, then we talk about time to put the roundtable.
Yes.
And
Yes.
time to put the comments in. The comments would, as I understand it, are going to be on any changes that were made from the prior 2 bills as far as Articles 9 and 12 are concerned. It will only include changes made varying from the prior one. And then Article 3, just whatever the next bill looks like.
Right. Yeah, the changes to 9 and 12 what we'll discuss on 9 and 12 are basically the changes that were made as a result of the governor's vetoes and how we treated those in the bill, how we incorporated it. But we'll have more than enough time to get coordinated on how we'll move forward with 9 and 12. Okay. All right. That was 2 hours. Thank you very much, and
Thank you.
we'll adjourn this roundtable discussion. Thank you.
Thank you.
No more roundtables?
Huh?
There's going
Yeah.
to be.